Brandon K. Wright is a partner in the firm of Miller, Tracy, Braun, Funk, and Miller in Monticello, Illinois. He has served as an adjunct faculty member at Southern Illinois University's Carbondale and Edwardsville campuses, as well as at Eastern Illinois University. Brandon currently serves as the chair of the executive committee of the Illinois Council of School Attorneys. Brandon focuses his practice on school law, having developed a particular interest in the field of special education, due process, and cooperative school districts. He regularly speaks at local, state, and national conferences on issues of school law and special education. Welcome, Brandon. We're ready to learn more.
Well, good afternoon, everybody. Thanks for hanging out today as we think about all the things that are going on out there in the world of school law that impact technology in different ways. So happy to hang out with everybody today and think about these issues that are out there in front of us today. And really, we're going to focus on 5 different areas that I want to talk about briefly this afternoon, and then certainly try and answer any questions that you all have as well. We've got a couple Supreme Court decisions that impact the school social media and school employee social media. So I think it's important that we talk about those Supreme Court decisions, continuing to see some emerging guidance on AI that we're going to talk about. We need some key reminders going into next school year on SOPA. The Department of Ed issued some guidance on assistive technology this spring, and we've got new regulations coming on web accessibility. So I think those are all really important legal requirements for us to think about. So let's jump right in and think about what those mean for us. But we're going to start with these social media cases decided by the Supreme Court here recently. You know, we're in that time of year where we're going to be getting new Supreme Court decisions every week. But we did in March get 2 decisions on the same day. One that is directly a school case, the other that certainly impacts school cases, and the other case, and we're gonna talk about them. The main case where the Supreme Court issued the lengthier written opinion that's going to impact these decisions is Lemke versus Freed, and this was a case decided by the Supreme Court on March 15th, the same day that the Supreme Court decided the O'Connor-Radcliffe versus Garnier case. Which we'll talk about also here in a little bit, but our main focus is going to be on the written opinion from Lemke versus Freed, which really deals with the issue of when we as school employees have our own social media accounts. At what point do we cross the line where that social media account might really be an official account for school purposes, for issues that might come under the First Amendment or other things when members of the public are interacting with us through that social media page and the impact it might have for us. So just to give you a little bit of the background of this case, the defendant was James Freed, who was the city manager of Port Huron, Michigan. And again, we could easily replace this with was the principal, was the superintendent, was some school official as well. As we'll see in the next case, that was directly a school official case. But Mr. Freed had a public Facebook profile, so anybody could see his posts. And his Facebook page was something that was both personal, but also maybe a little bit used related to his duty as city manager. It noted that he was the city manager. He operated the Facebook page personally himself. He mostly posted about his personal life, about his kids, but he did sometimes post information about his job, posting communications from city officials, and sometimes even asking and soliciting feedback on issues of concern within the city. And he would respond to comments on his post. If somebody commented, like, how come my trash didn't get picked up today? He might respond to that using his Facebook profile. So we start to see perhaps the trimmings of what we might call, or what the Supreme Court does end up calling, a mixed use account. And he would sometimes delete comments if he thought they were derogatory or stupid in his words. And one of those folks who posted comments that he didn't like was a Facebook user named Kevin Lemke. And Kevin would comment on posts, especially during the COVID-19 pandemic. And so we saw lots of posts related to the city's policies related to the pandemic. And initially the city manager here, Mr. Freed, deleted some of Linkey's comments. He ultimately blocked him from commenting at all, saying, hey, look, this is my personal Facebook page, right? I have the right to block whoever I want, to delete comments how I want to. Ultimately, the Sixth Circuit found that this was a personal page, not a state page, but the Supreme Court said, we need to create a test for this. All right, we need a slightly different analysis to look at this issue. And they said, we need to look at the totality of the circumstances to decide whether or not, when a public official is engaging on social media and is deleting or blocking comments in a way that might violate the First Amendment, if this is an official, government account operated for government purposes or for school purposes for us in the education setting, what's going on. And so the Supreme Court said, look, in order for it to be an official account, the school official or the public official has to actually have the authority to speak on the state's behalf on a particular matter and has to purport to exercise that authority in the posts. And they said, this is a new standard, go back, do it again, and have the lower courts review this. And Justice Amy Coney Barrett, who wrote the opinion for a unanimous court, said, look, you can't just say it's a personal page or claim it's a personal page and then actually conduct government business on it and think that the First Amendment might not apply. And so, the court said, look, there might be a high cost for using these mixed use social media accounts where we've got both personal and government related content, right? And we're going to have to look specifically as to whether this account is really used for any government related purpose in a way that might create, First Amendment issues. And we look at the content and function, right, of the post. For example, if you've got a hypothetical mayor posting to their personal Facebook page, pursuant to Municipal Ordinance 22.1, I am temporarily suspending enforcement of alternate side parking rules. Well, that starts to sound like an official government post, right? Not even though you're posting it from your personal Facebook page. And so we need to take that step back and recognize where that limit might be drawn. And ultimately, the court said, we're going to look at, custom or usage here. Whether or not the person could, theoretically make these announcements on behalf of the government entity, not just whether they do. That is an important piece to things. So if we're posting on our personal social media about things like official board business, school closures due to weather, all of those types of things, that can start to make it look like we are, operating an official account. And of course, it's got to be something that is within the content and function of that person's duties, right? If we've got someone who might be a lower level employee who doesn't have any responsibility for the area of concern, that's a very different analysis, the Supreme Court said, than maybe somebody like an administrator, the superintendent, someone else who might be able to look at that. And they said, and also, the label matters a little bit. And they said, look, the fact that, somebody labels it as their personal private page does create a presumption that it's personal and not an official account, but it is not automatic, right? And they said we have to look to the content and function as being the most important considerations. And when there are posts that expressly invoke the state authority or the government official's duties and job, then that's, might lead us into concluding that is an official account. So we've got Linkey versus Freed. The same day, we also had the Supreme Court vacating the Ninth Circuit's decision in O'Connor-Radcliffe versus Garnier. This case does involve a school. These involve school board members who had public Facebook pages that were initially there for their campaign when they ran for the board, but they converted those somewhat into public pages where they posted school district related content, board meeting recaps, soliciting applications for board positions, posting about the school's budget, posting other updates about the school, and sometimes did communicate with constituents in the community. And so, and there was also a Twitter account at issue in this this case as well. And here you've got other people who are now commenting, who ultimately got blocked and filed a lawsuit. And so again, we've got the Ninth Circuit, or the Ninth Circuit's decision being vacated, and said, look, because we decided Limke versus Freed, we don't need to decide this case. The Supreme Court said, go back and redecide it under the new standard. So I do think that this raises that important question for us, right? Are we talking about an employee's private personal social media page, or a mixed use account, or an official account that's engaging in real government business? And I don't know that this changes where I've been on this, and we've sometimes in these webinars in past years talked about that issue, but now we've got the Supreme Court, telling us, that we need to be clear as we look at the actual content, and custom and usage, and whether the account is purporting to engage in school district business. If so, then it's likely going to be treated as an official account for purposes of the First Amendment, where you could violate, a constituent's First Amendment rights by deleting their comments, blocking them, other things that are out there for us. So pay close attention to that. I think this will certainly have a lot of downstream effects as we see the lower courts looking at this over the course of the next several years, and we see this continuing to expand. But certainly an important starting point to think about, the Supreme Court's decisions there as it relates to social media pages, and when and how that impacts us in the school environment. So that's the first issue that's out there for us. I want to also mention a few things here as it relates to AI. And there's lots of resources out there from LTC that are probably even better and more tuned, and certainly get AI way better than I do. But from that legal perspective, I do think it's important that we are understanding what's out there. And I think one of the key resources for us in the educational community is the Department of Ed's guidance issued in 2023 on AI and the future of teaching and learning, and how we are really getting there. And within that framework, one of the most important pieces here that I put in bold is, as they're sort of even giving this introduction to what AI is within that guidance from the Department of Ed, they note, educational systems must govern their use of AI, right? And so as school districts, we do have that obligation to make sure that we understand what's going on, how it's being used, and the policy implications for that. I think in the world of education, we are really going to be excited about some of the opportunities that are there, but there are also, I think, some landmines as we, expand that use of AI and recognize that there is both good and bad only maybe insofar as we see people using it in some nefarious ways, or ways that our policy hasn't quite caught up to. And what I think is always true is technology is going to outstrip our policy, or, and so we need to have a policy that can be flexible enough to adhere to those changes for us. And so, I think that there are really important suggestions for us as we think about compliance with legal requirements like the IDEA and special ed, FERPA, confidentiality issues and privacy issues, other things that are out there for us. And we see some of that guidance out there from the Department of Ed reminding us that AI is a collaborator, not a replacement, right? And so AI has to work alongside the humans involved to help us collaborate, but not replace the decision-making required of the humans involved in the process for our educational decisions. It certainly can make efficiencies for us, and we need to find ways to harness that and use that, but also privacy is important, right? And we have to prioritize some of those non-negotiables, like the robust privacy protections we need to be thinking about from a cybersecurity standpoint, but also from a SOPA and data privacy standpoint under FERPA, and I think that's where, again, that call to action from the Department of Ed is that as AI is moving fast, right, we do need a national policy response, and that one of those existing frameworks that has to be a priority are student privacy, right? Like FERPA, like the Illinois School Student Records Act, like SOPA, those requirements that are going to impact us from that student privacy perspective. That's going to be really important for us, right? Department head says, what happens to student data when we're putting it into AI systems, how it's deleted, who sees it, right? These have to be major concerns for us as we think about that in the context of what that means, again, to comply with pre-existing legal requirements, whether that be our confidentiality duty under FERPA and the Student Records Act, our data privacy and security measures under SOPA and some of those requirements as well. So I think that's really an important piece that we can't overlook the important role that it's going to play. I think this is also in line with the president's blueprint on AI policy. President Biden did put out a blueprint, to all federal agencies, which certainly also includes the Department of Education, to again make sure that we are focusing on privacy and cybersecurity and how that data is used, what data is being scraped, and where it's going. And the focus on that, as you see here in this quote from the president's blueprint, is that we got to protect the data for all Americans, especially kids, right? So again, really having that focus on the student piece to that. So I think some of the key considerations we need to have front of mind as we think about how AI is impacting us in the education world, data privacy, compliance. So making sure we're always following our rules like FERPA, Student Records Act, SOPA, those have to be there. And a key piece to being able to do that might be how we can anonymize sensitive information. A concern I have is that if we've got teachers that are putting student information that includes identifying information into, a language model for AI, and now that data is being used and scraped for other purposes, are we exposing that student data and that student information in ways that may not be compliant with our privacy obligations? So how can we anonymize it? How do we limit that access? Make sure that we're not using copyrighted material. I think those are really important pieces. One of the major concerns that is certainly true in the legal world, and we already see some ethics opinions and decisions regarding attorneys' use of AI. But I think in the educational world is, keeping compliant with the privacy structures. And my concern in just real time is that you absolutely, unquestionably, no doubt in my mind, have teachers in your district who are already using various forms of generative AI for lesson planning, for grading student work, for generating work, for writing IEPs, for all sorts of things that people are using generative AI for. And my question is, are those, do we have in place, the data quality, the fairness, the transparency, all of that comes into play so that we can answer those questions about the risk that we have? Can educators answer the question, what are they going to use this program for? What do we know about this particular service? And does it create any security risks? And I might add another question that's going to sort of lead us to our next topic, which is, and is it SOPA compliant? And do we have a written agreement as an operator for us to be able to use that platform, right? And my guess and my concern is that you do have teachers and others in your district who are using various AI tools already, and maybe they're doing it on their own and not getting that appropriate, agreement and permission to do so under our SOPA policy and those things. So I think that is really important. I do want to go back and just remind us of a couple of these other considerations as we think about the use of generative AI that are out there. We see some guidance this past year from the EEOC concerned about, bias, whether that be on the basis of disability, race, or other factors when we're using AI and making hiring decisions and, working through applications or other things. So we want to make sure, again, that we are carefully looking at those fairness and bias and transparency considerations as well as we step into this brave new world of generative AI, which again, I don't think our policy can be, we don't do it, or we're going to block it, or we're going to prohibit it. I think we've got to embrace it, and we've got to embrace it in ways that keep some of those non-negotiables in mind. And those non-negotiables, of course, have to come back to recognizing, I think, a couple of these other factors, as I mentioned earlier. It's a collaborator, not a replacement. It absolutely has efficiencies for us that can expand what our human knowledge has to create better products. But that privacy and security have to be a non-negotiable as well. So I think those are some important things. And you're not going to hear me talk without some of those key privacy reminders for us when it comes to what SOPA requires for us here in Illinois. Again, we continue to see that, at least 75% of data breaches affecting U.S. school districts were the result of vendors and other third parties. So we again want to make sure that all of our EdTech vendors and our other partners with whom we're sharing digital and electronic data understand those requirements and have those reasonable security measures in place, right? So again, I think it's important that we're being proactive, that we're training employees in meaningful ways. Think about all the ways. As I'm sitting here, right, and I'm getting class dojo updates from my own kid's teacher, right, sitting here on my phone right now, I think about that again, coming back to what are some of those trainings for all of our employees from top to bottom to understand what security risks are, how to avoid that, and how to keep student data safe is really an important piece to it. So we've got to recognize that we've got to regularly test and monitor our systems, reassess because needs are going to change over time. I think that's really important. And really think about what that means and how we're training teachers to get us to those key SOPA requirements, right? So that we are protecting data in all the ways that we're supposed to be doing so, that we're training staff, and those training components of those reasonable security practices are really important for all employees, and that all employees know any new online sites, any services, any apps, any AI that we're using that might collect student data or covered information, it's got to be pre-approved. And if it's not approved, we can't use it. So that's really important. And just another, plug for LTC and their products to help you all manage that. I think that's a great service, and I encourage you to take a look at that. Again, some of the other things that stand out to me as potential areas of concern are when we're taking devices home and other settings, what is that going to mean for us from a cybersecurity standpoint, and that we continue to follow our own policy. And, most school districts in Illinois are going to use those press policy and procedures that set forth those requirements that require the superintendent to designate which employees are authorized to enter into those agreements, and specifically list those employees, that you're going to have a privacy officer or an EdTech committee who are making those decisions under that policy. So pay close attention to what's there. I think the summer is a great time before you start going into next school year to be taking a look at that policy one more time, look at some of the pieces in it that are optional, some of the pieces that aren't optional, and make sure that we are continuing to get in place all the things we need to do from an infrastructure standpoint on data privacy. But I think it's the human element is the weak spot. And so what are we doing to help train our employees to recognize and avoid some of those potential breaches that are out there for us? All right. As we're halfway through, let's shift gears into what is, uniquely a special education topic related to students with disabilities. But we do have, brand new guidance that, again, the law hasn't changed, but I do think that it's worth taking a look at. And a lot of us who live in this world of technology in the school districts are oftentimes also extremely involved in some of those assistive technology decisions, right? And what that means for us. And earlier this year in January, the Department of Ed did issue a Dear Colleague letter and a guidance document on the use of assistive technology devices and services. And so I think it is essential that we are paying close attention to that requirement. And so, you've got the link to that here. I'm not going to go through everything that's in that, but I do want to highlight some of the key pieces from that assistive technology guidance that I think are particularly important and instructive for us, especially those myths and facts, right? They went through and articulated 20 some myths and facts around assistive technology. I've picked out a few of those that I think for this group it's important to hear about, and certainly your special ed folks are paying close attention to that as well. But there are some pieces here that are important. And the first myth they want to overcome is that we only occasionally consider assistive tech, but they say no, we have to consider a student's assistive technology needs at every IEP meeting, right? Anytime we're reviewing and updating that IEP, and especially at every annual review, we are talking about assistive technology. And so we want to know that is a piece that's there, and trying to look at what are those options for us from an assistive technology standpoint that really are going to benefit students with disabilities in order for them to access the curriculum, make progress in their IEP goals, enhance their independence, all those things that assistive technology can help us do. I would point out as well, we've got some bills rolling through the General Assembly this spring. It is late May, and that is when we always have sort of an eye to Springfield and looking at what may be coming out in terms of new legislation this year. And we see some additional legislation on this that would connect assistive technology for older students to post-secondary education and employment and independent living. And so I think, again, there's a role here for us to think about that as well. And I think that we have to also recognize that part of that assistive technology requirement under special ed law at the federal level and the state level as well, obviously, is that we have to consider not only the need for an assistive technology device, but both AT devices and services. So maybe you're a school district that's already one-to-one and every student has a device. And so, an IEP student doesn't need a particular device, but maybe they need a service related to assistive technology. They need particular software, they need training, they need support, other things that might be necessary in order for them to meaningfully access that. So recognize that when we're talking about assistive technology needs for student with disabilities, we are talking about both devices and services. And that, generally we're relying upon an evaluation. Now, I do question this particular answer from the Department of Ed's guidance, where they say that we can make decisions here without a formal evaluation. Because even just today, I saw a case reported, I think, out of Maryland, where the failure to evaluate for assistive technology needs was a legal concern for a school district in terms of meeting those obligations for students with disabilities. So we want to make sure we're basing that on good data. And again, that consideration as part of transition, that is here already, sort of embedded in the guidance from the Department of Education. As I mentioned, there's a bill in Springfield that looks, likely to pass. That's going to specifically require us to think about assistive technology needs, again, both devices and services that would assist a student as they transition from high school into post-secondary education and employment and independent living. Those are things that we need to be actively thinking about. And I think this is an area where we can connect this back to things like that AI conversation, where we're seeing some really cool, and ways that AI is providing great assistance to students with a variety of disabilities. Students who have visual impairments, where there are some really, really well-designed AI goggles that sort of replace the need for a guide dog or even a cane to be able to navigate the natural environment and be able to communicate with them. The ability to close caption has become so much more ubiquitous, right? And for students with hearing impairments, that we see some mobility devices, some very smart AI based smart garments that help those with mobility impairments be able to move. And obviously students who have learning needs and academic needs, that there are so many ways that AI can help with reading and processing information and writing and being able to teach skills. So I think that there's some really important ways that AI is connected to this assistive technology piece, and certainly an area that we want to continue to think about and focus on for those needs going forward. But certainly it's not limited to AI as we think about that role for assistive tech and what that might mean for us. Again, the Department of Ed reminds us that assistive tech is not always high tech, that low tech devices are also included within assistive technology, that they might need to be used not only in the school setting, but in the home setting. This is an area I sometimes get pushback from school districts on, but the IDEA regulations are pretty clear that if a student with a disability needs to be able to utilize that device in the home setting in order to receive FAPE, in order to complete their schoolwork, in order to make progress, that might also include the requirement that a student be allowed to use that device at home, which isn't always a popular answer, but certainly something that the IDEA may require us to do. And then the other reminder, and especially for many of us in this group that do tend to work in that tech world, is that the IEP team makes the final call about assistive technology. It's not something that is can be trumped or vetoed by the IT department. And so, I think that's where we have to be working closely together to recognize that if an IEP team determines that a student needs a particular device or service, that we don't get to then go out and trump that, right, through other policies or procedures in the district. Now, we might have to have certain things in place, like making sure that it's the software we're using is SOPA compliant and go through those steps. We might have to come back and inform the IEP team about what the limitations of certain things are and work together collaboratively with the IEP team and the parent in terms of making those decisions in a way that's going to still provide FAPE to that student, right, and allow them to make appropriate progress and meet their IEP goals. But the Department of Ed was quick to remind us in this guidance as well that there are limits, because ultimately when it comes to the needs of students with disabilities, the IEP team is to be the decision maker. So if that means we need to incorporate or include or invite folks from our IT department to help inform the team's decision, then that might be something that we have to do and we have to consider when it comes to providing those assistive technology devices and services. So I think this is certainly, for me, an exciting topic because I certainly see the benefit and the real-time benefits of how so much technology has moved forward so quickly to meet the needs of students with disabilities in the educational setting. And that's, of course, a mandatory component of our consideration as an IEP team. I think there's so many connections to what that means for post-secondary transition. I think there are certainly clearly connections to how AI is also moving that ball forward in really meaningful ways to really permit students with disabilities to expand their options and their performance and collaborate to help in both academic and behavioral ways, as well as sensory and motor needs as well. So please pay close attention to that, know what's out there, and make sure that you know how and when you all as tech folks need to be collaborating with IEP teams and the special education department on some of those assistive technology needs. And a topic that is closely related to that, right, relates to our new web accessibility rules. So this is a piece that we're going to be probably talking about over the course of the next couple of years, understanding the implementation and what this means from a broad perspective when it comes to making sure that all of our information posted online through school district apps and everything else meets the accessibility requirements of the Americans with Disabilities Act and Section 504. This is not new in terms of the fact that OCR, the Department of Ed's Office of Civil Rights, as well as the Department of Justice, have been, using their enforcement authority under the ADA and Section 504 to address these issues. There have been one of the most common complaints, because you've got lots of people out there who just file lots of complaints. They go to school district websites. If those website doesn't meet the accessibility requirements, they'll just file a complaint. So OCR has been going through this with, hundreds and hundreds of school districts over the past several years to ensure that web accessibility requirements are there. They've sort of handled those on an individual basis to address those as complaints are filed. But we did just have here a month ago, right, in late April, the Department of Justice did file a final rule that takes effect June 24th, although compliance is really 2026 for most of us. That shows how all web content and mobile applications from units of government like public school districts meet the accessibility requirements so that they are accessible to people with disabilities. So again, the rules are effective in June of this year, but full compliance is in 2 years, right? April of 2026. So we need to get started on this. There are already complaints that can be filed, but they recognize that this will require a lot of work for school districts in terms of meeting those web accessibility requirements. So we've got, for most units of government, we've got 2 years to comply. Units of government with a population over 50,000, it's a shorter time frame, right? So we've got to recognize that time frame for compliance. And so what the rule says, right, is that our web content, our mobile apps, anything like that that's operated by the school district has to comply with the Web Content Accessibility Guidelines version 2.1 level AA, right? So that, if we have alternatives that provide the same or more accessibility and usability, we can use those alternatives, but they have to, at a minimum, meet those Web Content Guidelines 2.1 level AA. Now, my job today is not to sit down and go through each of those, right? And I think that's what we are going to have to spend time, as school districts over the next couple of years, getting all of our content going forward, in particular, to meet those requirements that are set forth. You'll find them in about 10 seconds, right? When you Google it to find out what those guidelines are. They're available there from DOJ and the Department of Ed as well in terms of that piece. But what I do think is an important note here, and you see it in bold on this slide, is that this is not only limited to publicly posted web content or mobile apps operated by a school district, but it also would include password protected content that is available to students and staff. So things that might be beyond, behind a password, those also are going to have to meet those accessibility requirements as well. So we need to pay close attention to that and make sure that we understand that those requirements are going to be there for us as we continue to add content. There are some exceptions in the rule. So archived content, pre-existing conventional electronic documents, content posted by a third party that's not under our control, individualized documents that are password protected, pre-existing social media posts that predate the rule. Those are things that are going to be some of the very few exceptions to the rule in terms of what's going to have to meet those accessibility requirements. But we are again going to have to work for content posted in the future, again, which includes even things that are behind our passwords on our intranet as well, things that are going to have to meet those web accessibility requirements, and something we're going to have to pay close attention to. And again, some of those requirements are really there now. I mean, OCR is, again, already resolving complaints when they're filed on that basis and requiring compliance when a complaint is filed. We now have regulations that make clear that compliance and have a timeline for that. So I do think that it's likely, given these rules, that we might see some more technical assistance in helping us get there from OCR if complaints are filed. But again, recognizing we already have some basic requirements that have long been interpreted, right? That our content has to meet those accessibility requirements. And that's something that we're going to have to be paying close attention to as well as we continue to proceed over the course of the next couple years. So those are the things I wanted to talk about this afternoon. So I guess at this point, for those of you who are joining us today, I'd open it up to questions to see, as we've talked through kind of that wide variety of issues, from social media to web accessibility and everything in between. What are some of the things that are out there that are questions that we can try and answer today before we wrap things up, to kind of know where we're at and what's going on for us. So, please feel free to jump in and ask questions. What's going on?
The WCAG rules are, I'm going to throw something in the chat here. And when you click on it, don't freak out, don't freak out, don't freak out. So there's a quick reference that doesn't look really quick at all. But it's actually really, really good stuff. So this is the big, long guidance document. But if you go in there and really kind of look through things, there's a little understanding this this guideline, and techniques and failure links. What's an example, what's a non-example, like all good teachers provide students when they're learning something new. WCAG has provided that for us as well. So yeah, it's something new to many of us. We have a couple of years to go to get there, but the tools are there for us.
I just to emphasize, that has been the most common complaint filed with Office of Civil Rights over the past couple of years, our web accessibility complaints. So that's not a new or unheard of issue where they're requiring districts to come back and look at that. And that individual complaints, I think, are still possible while we all work on that new requirement for accessibility under sort of some pre-existing guidance in terms of the level of accessibility required that's there. So I don't want us to believe that we have no obligations for 2 years. I think that we still have some obligations, obviously, especially to make sure that individual students have access to what they need to receive FAPE. But especially at those public-facing pieces, we need to keep that in mind as well.
Mm-hmm. Absolutely. So that brings a question to my mind, Brandon. If I'm a regular teacher and I post something up on my classroom webpage that parents can see and students can see and anybody on the web can see, is this something I'm going to have to, if it has to do with my educational activities, and I post an image of the worksheet that's due tomorrow, that's not copyrighted, of course,
right?
Will I need to make that document WCAG compliant?
When we look at the exceptions that exist as they currently are, and I think some of that we're waiting on some specific guidance from OCR to give us some more detail, but those exceptions are pretty limited. So
Mm-hmm.
If I go back and think about what they call like individualized documents that are password protected, there's some specifics beyond that, right? And as I'm working to commit those rules to memory, we'll figure out what that means in real time. But I think there are some certain things that will be accepted from that. But if it's not an individualized document that's password protected, the assumption, the presumption is that it's going to have to meet the accessibility requirements.
Yeah. Great point.
Thanks so much. Thank you.